Hello and welcome to the 63rd episode of Business Litigation TV. I'm your host, Jesse David Eisenberg, and this is the internet's most passionate show about business litigation. Today we're going to talk about depositions. Depositions are a key piece in the discovery process in a litigation case. All right, the plaintiff is the first person deposed, and then the defendants get deposed one by one, depending how many there are. And then possibly non-party witnesses will be deposed as well. Now, I stress to my clients before they're being deposed. And I'm going to take a step back. Just so you know, a deposition is where the opposing counsel gets to conduct a basically like an interview to get all information from the other side. All right. So if you're the plaintiff, the defense counsel will ask you questions pertaining to the case, pertaining to your life. It's pretty open-ended. There's liberal. The rules are very liberally construed to where you can ask each party just about anything within the realm of possibility. Okay, you can't go too far outside it, but there's a broad stroke you can brush with. Now, like I said, there's a court reporter. So everything's being typed down, and there is an official report. And the point is, that you want to get, the opposing counsel wants to get answers, so you can't change your mind later on or change the story. Okay? That's one of the points of deposition. Another one is just to find out what the other side knows, what they'll testify to. Now, the point of today's show is that I want to talk about how I have my clients comport themselves. Okay, so I always tell my clients the same thing. I tell them that, listen to the question asked and only answer that question. And what do I mean by that? Okay. I don't know if it's human nature or what, but a client wants to say, when they're asked a question, even if it's a yes or no question, they want to say yes, but, yes, however, yes, here's my life story. They always want to add more. Okay, I try and tell them you want to ask only the question. That's number one. Number one, I try to stress them, you're not going to win your case in a deposition. You can only lose it. Okay, you can give too much information. You can say something that's going to hurt your case. But you can tell the lawyer everything you possibly know. Tell them the whole story. They're not going to walk out of there telling their client they're screwed. Okay, it doesn't happen. All right? I mean, maybe once in a million kind of thing. What mostly happens is it turns into just word vomit, and the client ends up hurting themselves. Okay? So don't try and win your case in the deposition. And the third thing I say is to my clients, you're not in a hurry. Take your time, okay? When you hear the question, take a moment, take a breath, think about the question, and answer it, okay? I know it can be intimidating, but there's no actual hurry. Take your time, think about the question, answer it, okay? I've had more than one client get flustered in the process, and all of a sudden they can't even tell you which direction's up. All right, so take your time. And lastly, I remind my clients this is a trial run for the actual trial. All right, so don't be combative, don't be nasty. I know you think of the other side as the enemy, but don't, okay? Because if a witness does not perform well in a deposition, they don't tend to perform well at trial, right? And you want to give the other side the impression, hey, this is a credible witness who's going to perform well in the stand. It can only help you to be nice and charming and on your best behavior. Okay? So if you have any questions about litigation, depositions, anything at all, please feel free to email me at jesse@jdelaw.nyc or give my office a call, 718-966-0877. As always, thanks for watching.